Right, ladies and gentlemen, I'm going to start. Hopefully more will log on during my preamble, which won't be very long anyway. My name is Robert Fruin. I'm the Regional Surveyor with the CLA North team. So welcome to a joint effort between EMG Solicitors, CLA and H&H Land and Property on what I hope is a really useful and interesting property-based webinar for you. So we'll each take it in turn to do our talks. I'll be handing over shortly to Sam Edwards of EMG Solicitors. But just to say, this whole webinar is being recorded, so will be available afterwards if you need to refer back to it. We will take all the questions at the very end, please. So please type in your questions to the Q&A box that you can access on screen. Say, if it's directed at a particular panelist, do say so. If you need a call back afterwards, by all means, let us know. We've got all your contact details from the login, and hopefully we can help out further. Any of us can help out further as required. The CLA, my organization, Country Land and Business Association, we've got 30,000 or so members nationwide, 6,000 in the north, 10 million acres in membership, given that there are, broadly speaking, 20 million acres of agricultural land in England and Wales. Every other field that you drive by is owned by a CLA member. We do two things. We provide free advice, which is my principal job. I'm an experienced surveyor. And we lobby central government. I had a Zoom meeting day before yesterday with the new MP for West Ribble, trying to help sort out flooding down north of Liverpool. And so we do both those things. We'll get on with it now. And so welcome to Samantha Edwards, EMG Solicitors. As I said, she's going to be talking about protecting your family and estate. And so over to you, Sam.
Thank you very much, Robert. Hi, everyone. As Robert said, my name is Sam Edward, and I'm one of the directors at EMG Solicitors. We're a firm that specialise in private client work, and we have offices here in the northeast, but have clients nationwide. Personally, I specialise in wills, trusts and probate inheritance tax and head up our team. So today I'd like to talk about agricultural property relief, and I'll cover the basics really, but we'll focus on what's character appropriate for the farmhouse, which will encompass the definition of a farmer and what can happen. I'm so sorry, I've just lost my screen. So what can happen when a farmer retires. And I'll also move on to agricultural value and the interplay with open market value and indeed hope value. I'll look at business property relief and the potential this relief has in estate planning, and how you can use your will and a discretionary trust as a planning mechanism. And throughout, I'll try and highlight the recommendations that the Office for the Simplification of Tax made last year. Okay, let's move on then. If you could move my slide, please. And once more. Thank you. Let's look to the basics and say, what is agricultural property relief? Well, this is a relief from inheritance tax on the agricultural value of agricultural property, including land, woodland, cottages, farm buildings and farmhouses that are character appropriate to the agricultural land. The policy rationale behind this relief is to prevent the breakup of farms and businesses. Now, within this definition, there are two aspects I would like to focus on today, which are agricultural value and the character appropriate stipulation. Let's look first at the farmhouse and character appropriate. Now, statute says that to qualify for agricultural property relief, the farmhouse must be either occupied by the deceased for the purposes of agriculture for 2 years prior to death, or owned by the deceased throughout the 7 years prior to death and occupied by any person for the purposes of agriculture. So this begs the question, therefore, what is a farmhouse? Well, quite helpfully, there is no statutory definition whatsoever. So we looked at case law, which tells us that it's the place where the farming operations are conducted and the dwelling from which the farmer manages the farm. Let's have a close look at one particular case, and that would be Antrobus, which is obviously very well known, but it's the first case I want to look at initially. So Cook Hill Priory was the farmhouse. It was a 6-bedroom Tudor house with a chapel, various agricultural buildings, a summer house, a turret house, gardens, grounds, and 142 acres of land. Mrs. Antrobus was a farmer, and they say she was a farmer in every sense. So she drove tractors, ploughed fields, carried out husbandry duties, delivered calves, helped with lambing. She was hands-on, and this is of particular importance, but I'll return to that fact. So the revenue argued that the dwelling was not a farmhouse. They argued it was a dwelling of a wealthy man, and the farming business was not in keeping with the size and nature of the priory. They also argued that the lack of profit the business made was a significant factor. However, the court held that profitability was held not to be a conclusive factor. It was held that the priory was, in fact, typical of the farmhouses in the area, so that agricultural property relief would apply, but only at the agricultural value. And I will return to this and Antrobus shortly. Let's move on now briefly and look at the definition of what a farmer is. So the farmer is the person who lives in the farmhouse in order to farm the land comprised in the farm, and who farms the land on a day-to-day basis. A house occupied with a farm, however, is not necessarily a farmhouse, simply because the person living there is in overall control of the agricultural business conducted on the land. Yes, a farmer must be hands-on and not merely a lifestyle farmer, but we must remember that the farmhouse, along with farm cottages and farm buildings, is an ancillary aspect of agricultural property relief. It's therefore a prerequisite that the agricultural land is the dominant feature. But further, for the farmhouse to qualify for agricultural property relief, there must be an objective connection between the occupation of the residential property, the farmhouse, and the agricultural activities on the land. So let's look at what is character appropriate. Now, there are 7 points that the courts have asked us to consider, and we consider them in the round and take a balanced view once we've answered them all. The first is the house appropriate in its size, layout, content, style, quality of construction when taken with the associated farmland? Next, is the house proportionate in size and nature to the requirements of the farming activities conducted on the land? Would a reasonable informed person, so the man on the rural bus, regard the property as a house with land or as a farmhouse? With number 4, we get, within the agricultural land, does the house dominate, or is it clearly ancillary to the land? At 5, how long has the farmhouse and the agricultural property been associated? Is there a history of agricultural production? Penultimately, we look at the relationship between the value of the house and the profitability of the land. We ask the question, would the house attract demand from a commercial farmer who has to earn a living from the land, or is its value significantly out of proportion to the profitability of the land? And finally, my favourite, the elephant test. Would you recognise it as a farmhouse if you saw it? This is what they call an instinctive test, to rule out extremes on either side of the scale. So let's think about what happens if the house is character appropriate, but the farmer takes a back seat. He allows the land to be farmed by others, perhaps. Would the revenue seek to deny agricultural property relief on the farmhouse? Well, this narrower definition of farmer can affect working farmers who, perhaps for health reasons in the latter part of their lives, decide to step back from day-to-day farming. So let's consider retirement, and is it sufficient to let land on grazing agreements and retire? Well, in light of the decision in McCall and Keenan, it is important that the activities carried out by the landowner go beyond the maintenance and management activities that are directly related to letting the land. They must actually reflect the fact that the landowner is farming the land. And so that is one important key factor. But what will happen if there's an absence from the property? If the person who leaves the agricultural property vacant and is not in occupation? Well, it depends on the circumstances. So vacating a property for remedial work, for instance, or because of ill health might put the availability of agricultural property relief at risk. It really is a question of fact and degree in every case. So a necessary absence where a building is repaired would normally probably be disregarded, provided that the works are carried out quickly in a business-like manner. But where the absence is due to ill health, the intentions of the absent owner are relevant. For example, the likely length and severity of illness and whether they intend to return to the property once they've recovered. And this, I think, is what we class as a very unfair restriction on the application of agricultural property relief. Now, there have been two quite recent developments that I'd like to talk about. The first is the recent, I'm saying it's 2019, but the case of Charnley. This is where Mr. Charnley had 22 acres of land which he let to local farmers for the grazing of their livestock. Agricultural property relief was refused due to the lack of connection between the occupancy of the farmhouse and the farming activities, but this was overturned as the executors provided proof that Mr. C remained actively responsible for the maintenance of hedges and fences, weed control, topping, and the evidence that they used was the form of Mr. C's own written records and his photos, because he used to write every day what he used to do. These written records, together with the statements from the farmers who used his land, helpfully got that decision overturned. Now, the statement was really useful because one of the farmers had said it was as if he was farming his own land but using my stock, which I rather like. Now, the second development is a recommendation from the Office of Simplification of Tax. Now, in the report, they recommend that the Revenue should review their current approach around the eligibility of the farmhouse and agricultural property relief in sensitive cases, such as when a farmer needs to leave the farmhouse for medical reasons or go into care. And if this obviously goes through to legislation, it would be a welcome change. Excuse me. I'm going to move now on to agricultural value. And I would like to do so by returning to Antrobus, but the second time that this came to court. So it was held that Cookhill Priory qualified for agricultural property relief, but only the agricultural value would pass free of inheritance tax. So if you could turn my slide, please. Thank you. Let's look at the definition of agricultural value, and it's here on the side. The value, which would be the value of the property if the property was subject to a perpetual covenant prohibiting its use otherwise than as agricultural property. It therefore excludes any part of the value attributable to its any other potential alternative use. Now, the executors held that the agricultural value of Cookhill Priory was identical to the open market value. Now, open market value is the value that we value anything for inheritance tax purposes, and it's what the Revenue requires. The Revenue and the court held otherwise. They held that 70% of the open market value equated to the agricultural value, so that 70% of the value of the property passes free of tax with agricultural property relief, but the balancing 30% would be chargeable to inheritance tax, possibly at a rate of 40%, bearing in mind the nil rate band and the residential nil rate band would not be applicable. So this open market value, it reflects the value that a non-farmer would be prepared to pay a premium for the farmhouse due to its attractiveness or its convenient location. And I think this probably takes us nicely onto hope value. So let's say, what is hope value? Well, it's the open market value based on the expectation of obtaining planning permission or based on the development potential, but it is regardless of any intention of the owner to actually develop it. So it's just the potential itself rather than any intention to do anything with it. So you may have a derelict building which you would never think of converting, but the fact is, on your death, the district valuer is appointed and they look at it and say, well, this could be a residential property, and give it some hope value which could be taxed at 40%. A nasty surprise. So let's look at what the valuation office will do. The valuation office will look to identify hope value in three main areas. The first is in land or buildings in close proximity to an established settlement. The second is in any farmhouse in a desirable area, such as an area of outstanding natural beauty or a national park or a commuter belt. And the third perhaps is where there is pre-existing diversification. So what I always ask my clients or recommend my clients to consider is to look at whether there are any property that perhaps could benefit from permitted development rights in the town and country planning legislation, perhaps under Class Q where there's a change of use from agricultural to residential. I would ask them to consider the development value in any redundant farm buildings. Now this is really important because the revenue ask explicitly about the use of buildings for agricultural purposes. And I would recommend that a critical eye needs to be cast over any dilapidated or outdated buildings that are not put to an obvious or unambiguous agricultural use. And I think further, I'd just like to talk on farm buildings, is that the revenue do actually advise the district valuer to investigate the values where all the land is let for mowing or grazing and there are extensive farm buildings. They ask the district valuer to consider it may be that then all the buildings or structures are occupied for agricultural purposes, and so that relief will not be available for buildings which are derelict. Now, all of these things can be taken with the fact that the personal representatives of any estate have a duty to make proper investigations into the value of all property, and a professional valuation in this respect is of utmost importance. I can't emphasize enough how much support and their knowledge is important for having a chartered surveyor on your side who can talk to the district valuer, because the district valuer is often instructed where there is an asset difficult to value, which can encompass anything with hope value, or it appears it has been undervalued. So let's say we do have a farming business with a dilapidated building which may have hope value and we cannot get agricultural property relief on it. Can business property help? Sorry, can business property relief help? Well, this is a relief like agricultural property relief, but it's a relief where an interest in a trading business which has been held for at least 2 years may qualify at a rate of 100%, so that the interest passes free of inheritance tax. But it really depends on your ownership structure. So for instance, if you own the land and buildings personally and farm in hand, you may well get agricultural property relief at 100% on the agricultural value. But business property relief will only be available at a rate of 50% on the other open market value. This is where a partnership can often provide a helpful vehicle. Because if the land and buildings are introduced to the partnership, they are converted into an interest in capital of the partnership and may qualify for business property relief at 100% if, and it's a big if it is classed as a trading business. Now, to class as a trading business is an important test called the wholly or mainly test. In the case of Balfour is the authority. Now, where a business is deemed wholly or mainly trading rather than an investment business, it will qualify for business property relief. A business may still have an investment element, but it must be ancillary and not dominant. The decision in Balfour consolidates the line of cases involving composite businesses that started with the case of Farmer, and which looks at a number of factors when weighing up whether your business is wholly or mainly trading, such as turnover, profit, capital value, time spent, and they examine all of these in the round to see which is the dominant activity. Is trading the dominant activity? So for instance, where you have a farming business with a holiday let within the business, the holiday let is deemed to be an investment business and would not normally get business property relief. But if within the business as a whole it is just an ancillary part, business property relief can apply overall. Now, the Office of Simplification of Tax has queried this wholly or mainly test, so that whilst at present, if a business is even 51% trading and 49% investment, it can pass the test. And business property relief at 100% can apply to all assets, including those of the investment nature. But the report, as I mentioned, which was provided to the Revenue last year, highlights that the requirements about the level of trading activity needed to qualify for business property relief are different to the comparable conditions of two of the main business reliefs for capital gains tax. They say it's unclear why there are different tests for different tax reliefs relating to the same business, which potentially distorts decision making in choosing between whether to transfer businesses during life or death. It recommends that these reliefs are brought in line so that the tests are standardised, and this would mean that the test could rise to an 80% test, so that 80% of a business must be trading, which is a huge difference and a real reduction in what could potentially qualify for business property relief. So if you could just move my last slide, please, I'm going to move on to wills and trusts. So let's first of all think about what we can do with our will. Well, let's look at what we should consider. Who should benefit? Well, is it your spouse, children, grandchildren, any other person important in your life, or charity? We also need to think about what you want to achieve. Is it financial security? Are you concerned about a beneficiary's financial maturity or responsibility? Are you worried about their involvement in the business and the continuation of the business? We also must think about the assets in your estate, any gifts that you have made, and the application of the nil rate band and whether your estate can qualify for the residential nil rate band. But in terms of assets that qualify for reliefs from inheritance tax, like agricultural property relief or business property relief, I recommend that a specific gift of any assets qualifying for relief is passed to a chargeable beneficiary, and therefore a person or trust that without the relief would otherwise mean inheritance tax was payable. So I'm saying don't pass anything with relief to your spouse, because a spouse will inherit anything tax-free in any event because of spouse exemption. Now, I'm saying this for four main reasons. The first is to ensure the relief attaches fully to the agricultural or business property. The second is to ensure the relief is not wasted on a beneficiary already exempt, as I've talked about spouse exemption. The third is to remove assets from the survivor's estate for qualification of the residential nil rate band. And what I mean by that is that your estate will not qualify for this extra nil rate band unless the value is under £2 million. And that value does take into consideration the value of your agricultural and business property. Even though it may qualify for relief from inheritance tax, the value is taken into consideration when qualifying for the residential nil rate band. And finally, and perhaps most importantly, the risk, which is perhaps growing ever larger, that the relief will not be available on the death of the survivor. And what I mean by that is that you leave all of your assets to your spouse, and a few years later, on their death, business property relief or agricultural property relief has been severely reduced or removed, so that on their death, all of the assets are taxed at 40%. Whereas if you make the gift on the first death of relievable assets, you have captured that relief and saved it from inheritance tax on the survivor's death. Now, this gift of relievable assets can be made down to your children. And I have many clients who have done so, especially where children are working in the business. But as we know, no one knows what will happen in the future. So you may gift to a child who then divorces or becomes bankrupt or dies, and your property is then in each of those financial assessments or estates, and we could lose property that way. There is a way, however, of protecting your estate, which is by making a gift of relievable assets into a discretionary trust, which protects for these unknown circumstances. Now, the reason a trust protects is because no beneficiary has a right to anything in the trust. It is entirely a decision for the trustees as to who benefits, when they benefit, and to what extent. It is possible to make the survivor a trustee, with the power to appoint and remove trustees so that they, in effect, control the trust in its decisions. And the trust itself may just be a vehicle for the trustees to check on the first death that the children are in a good position to receive assets in the trust, so that it could actually be wound up without any tax consequence within 2 years of death. Or, at the time of the first death, if a child is divorcing or being made bankrupt, the assets can remain in the trust indefinitely, or at least until that child's estate is safe from attack. It allows the trustees to consider all of these influencing factors at the right time that they need to be considered. The other aspect is tax. You pass the relievable assets into the trust so they're not in the survivor's estate for inheritance tax purposes or the calculation of the residential nil rate band. And this can really help with trying to mitigate tax, especially where the residential nil rate band might apply. But also, a discretionary trust is flexible and it can be used to suit any family circumstance. For instance, loans can be made to grandchildren to buy property. The trust acts as their bank and places a charge on the title to their property, so that if in the future they divorce, the trust has priority over that loan sum and it is not lost in the divorce, where a simple gift would have been. Or if you have cash in the survivor's estate, whether it's from a life policy or not, assets can be purchased from the trust, which will take the cash outside of inheritance tax immediately without the 7-year clock, and the relievable assets will be back in the survivor's estate to try and gain that second bite of the cherry in case relief does actually still exist at their date of death. So a discretionary trust gives the benefit of taking into considerations relevant at the date of death, which we cannot do. It's kind of like a gift of hindsight. So I am, as you can tell, I think, always very happy to talk about wills and trusts, probably until the cows come home. But my message today, in conclusion, is that you should carefully consider your estate and the assets within it, identify potential property now, and try and prevent any nasty surprises, and try and plan in life and through your will to gain the best tax position for your family. Please, if you do have any questions or would like to talk to me about your own estates, please do contact me. My details are on screen now, and I'm very happy to talk virtually if this is more convenient. Thank you very much. I'd now like to hand over to Robert from H&H Land and Property, who will talk about contract farming agreements. Thank you very much.
Thank you very much, Sam. Good afternoon, everyone. I will just share my screen with you here. Okay, hopefully you can all see that. So, yes, good afternoon. My name is Robert Schneiko. I'm a chartered surveyor here at H&H Land and Estates, based in our Durham office. We do a wide variety of private client and estate management work from this office all across the North East and North Yorkshire, really. Today, I'm going to be giving a quick whistle-stop tour through contract farming agreements, what they are, what they look like in practice, their benefits and disadvantages, things to watch out for, and just a general overview of how to use them in practice. So, first of all, it's all well and good, I suppose, using the term contract farming agreement, but what actually is a contract farming agreement? In very broad summary, it's effectively a joint venture between the landowner, who is usually referred to as the farmer for contract farming purposes, which isn't all that helpful, and the other party being an appointed agricultural contractor who undertakes the vast majority of the work on the farmer's behalf. The farmer remains in occupation of the land, which is an important part of a contract farming agreement that we will come on to later. There is no tenancy created, which is again important for various reasons, which we'll again come on to later. There's various benefits to contract farming agreements and differences to that make it keenly different from a tenancy agreement for land. So what does the farmer or the landowner do in a contract farming setup? Well, firstly, the farmer needs to provide the actual land and the buildings for the appropriate farming system. The farmer will also usually provide a bank account with an overdraft facility, and that bank account is where the income and expenditure for the farming operations is typically run through. Importantly, the farmer must take a genuine active role in the management of the farming system. That is absolutely key if you are using a contract farming agreement for its, say, tax benefits. What management looks like can vary, but it can, say, include regular meetings with the farm contractor to provide instructions on cropping or ordering seeds and inputs and that kind of thing. But again, I shall come on to the importance of that active management role just a touch later on. So what does the contractor do in comparison? The contractor is responsible for the labour requirements to farm the land, as well as providing the machinery, the expertise, the time. They can order the inputs, and they'll obviously then spread them and undertake those cultivation works to establish the crop. They are usually paid for by the farmer though, and again that is run through the bank account that's been set up. So in summary, the contractor undertakes all the actual farming operations, usually to establish, grow and harvest the crop at the instruction and the direction of the farmer or the landowner. So how does a contract farming agreement work in practice? I thought it would be useful to show a quick flyby of what a contract farming agreement looks like in reality when they're run on the ground. First things first, it's crucial to have a suitably drafted contract farming agreement with all the terms agreed between the parties right from the off. If you don't have a formal agreement in place that deals with all the various aspects, you're asking for disputes, and the best way to avoid a dispute is to simply not have it in the first place. And if you've got all your terms written down in black and white on the paper, you're minimising your chances of a dispute cropping up. The farmer will discuss a suitable cropping plan with the contractor and provide his instructions, and they can be done in writing as well. And the farmer will then instruct the contractor to establish the crops on the basis that the parties have agreed. The farmer will have a separate bank account to handle income and expenditure that all the income and expenditures run through. The farmer will usually pay the contractor their first charge, which is the first payment and reflects a payment for the contractor's time and other costs involved in establishing that crop, sometimes on a per acre basis, so it can be any amount agreed by the parties. Importantly, that is the only guaranteed payment in a contract farming agreement. There is no guaranteed payment to the landowner in a contract farming agreement. The contractor will establish the crops and applies various inputs, such as the sprays and fertilizers. Importantly, the growing crop remains the property of the landowner. It's not the property of the contractor. It is at all times, unless it's sold at some point, it belongs to the landowner. Crop is then harvested and sold. The sale proceeds from the sale of those crops will be taken into the nominated bank account. The farmer, the landowner, will collect the first payment, usually referred to as the farmer's retention, but it can be called a few things. And once the farmer has taken that first chunk, the remaining surplus is usually split on a percentage basis between the parties, and that percentage split is usually and best agreed in the contract farming agreement. I think that's probably key to avoid any disputes on where the money goes, and the process is thereafter repeated as required. So just a quick note on the treatment of the basic payment scheme when the land's being farmed under a contract farming agreement. The farmer remains in occupation of the land for BPS purposes, and the entitlements remain held and used by the farmer or the landowner. If the farmer submits the BPS claim and collects the payment, and I think that is a crucial difference between when you're using a contract farming agreement and a traditional farm business tenancy, where because the tenant in a tenancy situation is in legal occupation of the land, that excludes him, the landowner, the landlord in that case, from claiming the BPS because he isn't in occupation of the land. whereas that is different to a contract farming agreement where the landowner is in occupation of the land and therefore can claim the BPS. So some benefits of a contract farming agreement over, say, a farm business tenancy. Typically, a contractor will be able to farm the land at a relatively lower cost than the landowners' costs of doing the same acreage in isolation. If the contractor is farming 3,000 acres, then they will be able to spread all of their fixed costs over all of that area, including the, say, 200 acres of the relevant farm, and on a per acre basis, therefore costs much less than the farmer buying all his equipment, all the depreciation, all the maintenance, all the repairs to farm that couple hundred acres in isolation. There is no tenancy created. There is no security of tenure other than any rights granted in the contract farming agreement, which is the same as any legal contract. If the farmer is contemplating retirement or perhaps taking a step back from actively farming the land themselves, a contract farming agreement can be a good sort of halfway house. They are still undertaking farming technically. They are still involved in management, but they're not out all day, every day, drilling, spraying. They can pass a lot of that labour requirement onto their contractor. Another point, contract farming agreement allows more control for a landowner over how their land is managed. The contractor is at the end of the day under the instruction of the landowner, and it's much easier to achieve that management control when comparing that to a tenancy. The landowner has no machinery they need to worry about, no associated depreciation, no ongoing maintenance of that machinery. That part of proceedings is passed on to the contractor, and that is their responsibility to provide. As the contractor is being paid a percentage split of the divisible surplus of the money generated from the cropping of the land, that incentivizes the contractor to make that land as productive as possible. So obviously the more income derived from that land by the contractor, the greater their percentage share, which in turn is obviously a greater percentage share for the landowner as well. So it's beneficial for both parties to extract maximum value out of the land. Some disadvantages. When there's benefits, there's always disadvantages. There is a genuine requirement for the landowner, the farmer, to take a genuine active management input into the farming of the land. He cannot simply put the agreement in place and then take a step back and just let the contractor get on with it. The importance of that and how that's viewed I'll come on to on the next slide, but the farmer should document management meetings with the contractor or wherever they've had any management input, so that if required they can quite clearly demonstrate, here, look, I've been involved with the management of this farm holding, I have been the farmer, albeit employing a contractor to do a lot of the cultivation works for me. Another disadvantage, probably a key one, there is no guaranteed financial return for the landowner. If, let's say, the weather hits, there's a disastrous crop, there's no profit made from that land from the year, that is the risk that the farmer is exposed to. That is a stark difference to a tenancy where the landlord will get his rent on a per acre basis that's agreed perhaps years ago. Doesn't matter how well the crop does, the landlord in that case will get his rental return from the land, hopefully. The contract farming agreement therefore represents a much greater risk than a tenancy, and that exposure to business risk is important. So the tax position, I'll just touch on this, given Sam's already given us a bit of a introduction into this. Contract farming agreements are often used for their tax benefits or potential tax benefits, and if properly managed, a contract farming agreement can help provide extra relief from IHT by providing additional agricultural property relief, as Sam's mentioned. I won't go into a great deal, but a good example of this again is where the farmhouse is involved. And just to expand on Sam's presentation a little bit, let's take a situation where the land is let out on a tenancy, but the landlord is remaining in occupation of the farmhouse. No agricultural activity is taking place in that farmhouse. It is being occupied separately to the land, and therefore APR won't be applicable on the house, which is potentially could represent a quite large tax liability depending on the particulars of the case. However, if a well-managed contract farming agreement and a genuine one is in place, and let's say there's management meetings taking place in the farm office, the farm business is being run from that office, the farmer is residing in that farmhouse, then it is being used for agriculture. The farmer occupies the farmhouse, and therefore at least an element of it, and that's where Antrobus comes back in again, is eligible for APR on that farmhouse. HMRC will consider the realities of the situation. They won't simply look at what's written on the page. If there is a contract farming agreement in place and it says bold letters at the top of the page, contract farming agreement, that won't tick the box. They'll be looking at the realities of the situation, how the farming operations are being run, and make their decision based on that. They'll look at, is the farmer exposed to business risk as any other owner-occupied farmer is? Are they taking that management input of actually farming the land rather than simply letting a contractor do their own thing? If HMRC deem that the contract farming agreement is fundamentally a tenancy agreement in all but name, they'll treat it as such and direct the relief as they see fit in that way. An interesting case here as to sort of how that applies in practice and the importance of genuine management input. Fife versus Esselmont, which was a case in 2018. This was a Scottish case, but I think it does have an implication for England as well as to how the courts will look at these sorts of situations. In this particular case, the tenant farmer on an agricultural holding was farming the land entirely with contractors. He was taking no real business risk himself. He was just letting the contractors do their own thing, farm it as they saw fit, and collect the crop off it. And in return, he got a set payment, so it was effectively a rent. There was a contract farming agreement in place. However, as I've just said, the court looked at the facts on the ground, and decided that agreement, the whole setup, was a sham, and they actually removed that tenant's 1991 Act protection, which is largely equivalent to our 1986 Act, Agricultural Holdings Act protection in England, as he was found to be in breach of tenancy because he was in effect subletting to that firm of contractors. And I think that's a good representation of how the courts they're not interested in what the words on the page say. It's the setup in practice and interrogating it further than what the words say. So in summary, contract farming agreements, useful tool in the correct situations, need to be carefully managed. It can allow for the productive and efficient farming of the holding as long as they are being run as they should be. They do have the potential for tax benefits, subject to what I've just said there. They expose the landowner to a greater degree of risk, but they do also allow for potentially higher returns in the best years in comparison to a rental income. And I would end by simply saying, if you have any uncertainties, I can't recommend enough just taking professional advice to understand the position and how HMRC might look at the format of the agreement and the situation on the ground to understand any potential liabilities going forward, or how those liabilities could be reduced to maximise your tax relief where possible. Finally, thank you very much for listening. I'm happy to take any questions at the end. I shall pass you on to our next speaker, who is Tim Sedgwick, also from our Durham office, Associate Director here at H&H Land and Estates, who's going to talk about the future of agricultural policy and support. Thank you very much.
I've unmuted my microphone now as well, so hopefully you can hear me. I'm here to talk about English domestic rural support schemes in a post-Brexit world, which is an introduction, but by no means a conclusion. Having issues with this, and so this afternoon's topics is the basic payment scheme and greening, the timescales for the change, countryside stewardship schemes, catchment sensitive farming and water capital grants, the countryside productivity small grant scheme, delinking and lump sum, what do they mean, and what might the environmental land management scheme look like, and the sustainable farming incentive. So the basic payment scheme, for those of you who don't know, I'm sure many do, it replaced the single payment scheme in 2015, and before that the single farm payment. There's area-based payments on 3 regions, non-SDA, SDA and Moorland. BPS entitlements are required to trigger payment. I'm sure many of you have traded entitlements, been involved with buying and selling of entitlements in the past, and there is an active farm requirement which is lessened off in recent years. Basic payment scheme is applied by the 15th of May each year, and the payment window opens on the 1st of December. Not necessarily everybody gets paid when the payment window opens though, of course. So it's a online application through rural payments, more rarely a paper application. There are some who still do a paper application. The dreaded hourly 1 forms and plans to change field parcels and ineligible features, they're still a thing, and the payment for the SDA and non-SDA regions is approximately £85 an acre. Now, to get the basic payment scheme, you're required to follow cross-compliance rules and others. Hedgerow protection, 2 metres from the centre of the hedge. I've had many clients in the past sadly fall foul of their inspector of ploughing too close to a hedge and drilling. Rights of way protection and maintenance. Other issues inspectors have found where public rights of way, there's a crop of maize in the way where people want to walk. Now that's common because people aren't walking it, but still you will fall foul of an inspector. NVZs, nitrate vulnerable zones, animal welfare and registration, movements and passports for sheep, livestock, cattle, and soil protections, previously soil management plans, and many more. So people will be pleased to note that the greening element as part of the basic payment scheme has been removed for the 2021 scheme year. That was obviously greening is the 2 to 3 year crop rule, fallow areas, nitrogen fixing crops, field margins, hedgerows and cover and catch crops. Just a reminder there that cross compliance still applies. So the phasing out of the basic payment scheme 2021 for the agricultural transition period. Unfortunately, despite requests from various farming representative organisations, that I think the CLA being one of them, that the transition was delayed due to COVID and the issues that's caused. Unfortunately, the direct payments are going to start to reduce in value in 2021. Now, it'll be the same value when it starts to be paid out later on this year, but the BPS 2021 payments are going to be reduced in line with that payment band there. And it's in stages how it's reduced. Okay, so but the approximately £3 billion that comes from the Common Agricultural Policy, or has come from the Common Agricultural Policy, is said to be ring-fenced for the life of this Parliament by domestic funds. Interesting to see what pressure they come under, and that BPS money, as it's reduced, is said to be diverted to in further countryside stewardship options and ELMS trials, productivity grants, delinking and lump sum payments. So the timescales for change, see 2019 2020 has been business as usual despite all the goings on with Brexit, and come at the 1st of January 2021 will start the agricultural transition period through to 2028 as planned, when there will be no direct payments, no BPS whatsoever, and in up to 2024, 2025 is when ELMS will come in. So there is concern amongst many in the farming community that there will be a cash flow gap in those periods. So countryside stewardship schemes in 2020, let's talk about what we know and what happened with countryside stewardship. It launched for applications in February, and the application window closed on the 31st of August 2020. It was meant to close end of July. It was extended due to coronavirus. There's a mid-tier scheme, higher tier scheme, water capital grants, and also hedgerow and boundaries grants. So the hedgerow and boundaries grant, what is that? It's a capital grant of up to £10,000 across farms, and there's a payment of £25 a metre for stone wall restoration, with further grant money available for the stone wall. £9.50 a metre for hedgerow gapping up, £8.80 per tree for the planting of hedgerow trees, and many more available. We believe this is due to reopen in February 2021 as a one-off capital grant scheme. There are some of the items that could be used in the hedgerow and apply for in the hedgerow and boundary grant. Wide range of things there, I'm sure you'll agree. So on to countryside stewardship, in particular mid-tier, that's the most common one. 5-year agreements. There are annual options which farmers and landowners can enter into, and there's rules for each of how to implement and follow them. Many can be quite complicated, involve photographic records of condition and such like. It can include a 2-year capital works programme of hedgerow planting, dry stone wall restoration or concreting, or new muck midden covers if it's in a high priority water area. Now you'll note that I was touching before on the hedgerow and boundaries grant, that's capped at £10,000. However, when doing a 2-year capital works programme, the grant money is potentially unlimited if it's accepted. So obviously it's a competitive scheme to apply for, but based on the low take-up and applications to date, most agreements have been accepted. Again, quite small text, but these are some of the annual options that people can look at. So quite a common one we're being involved with is the winter bird food option, which quite a lot of arable farmers have been looking at. These aren't all of the options. There's a wide range of them, but these are some of the things you can do. The autumn sown bumble bird mix is what a few others of our clients have gone on to do. Some more over the page, again a bit maybe more too small a text, but just gives you an idea of all the options that are available. Catchment sensitive farming and water capital grants. Okay, so the water capital grant, if you chose to do that as part of countryside stewardship, that is also limited at a £10,000, whereas doing it as part of a 5-year mid-tier, it would potentially be unlimited. So catchment sensitive farming, what is that? A partnership between DEFRA, Environment Agency and Natural England, and working to improve water and air quality in high priority areas. High priority areas in the northeast, around the Skern catchment. There's a lot in North Yorkshire. There is up in Berwick as well. So there's some fairly big high priority areas, but not everybody is covered. So catchment sensitive farming offers free training, advice and support for grant applications, and you do need the support of the local catchment sensitive farming officer for these water capital grants. And these are some of your water capital grants that you can look at. On there, some more. The main one is roofing, RP28. That is a good one, which people have got, needing planning, of course, but to get a grant to roof over a manure storage area, livestock gathering area, it's looking at £62 square metre. And again, there's the outdoor concrete yard renewal, RP15. That's £27.14 square metre as a contribution, which is a very good reward for doing that. I'm sure you'll agree. So a quick word on existing countryside stewardship schemes and HLS agreement holders. There may be those who are in the audience who still have a HLS agreement, or who have a countryside stewardship scheme approaching expiry when they took it out in 2015. Okay, so most existing schemes that we're aware of that are due to expire this year are being extended. That's if there are no major breaches. You'll likely receive an inspection to double check whether you have any breaches or whether you are undertaking all the options in accordance with the agreement you signed up to. And HLS, that'll be 10 years ago. It does avoid a reapplication process, and we would advise you now, if you're in that position or in general, to liaise with Natural England, try to develop a relationship with an individual there to take it forward. Obviously, higher level stewardships are particularly more valuable and user friendly than countryside stewardship as it stands. So it's better to stick with your higher level stewardship if you can. Quick word on the Countryside Productivity Small Grant Scheme, which opened for applications last week to much fanfare. The deadline to apply is the 4th of November, and there's 40% grants available for such items as listed on there: livestock handling systems and crushers, EID systems and readers. This is part of the government wanting to see farmers using more robust systems and improve animal health and welfare, resource management and precision farming equipment. It is certainly worth looking into. So looking ahead into the transition, delinking and lump sum, what does that mean? We've seen how the direct payments of BPS will start to drop. Hopefully that will lead to a simplified countryside stewardship and leading to a sustainable farming incentive and environmental land management scheme. There is consultations to be had on how to deal with the remaining direct payments. That's when we talk about delinking and lump sum. Will they be used as a retirement slash investment incentive? So there is due to be, or we've talked about, a public consultation from DEFRA later this year, early next year, on the delinking of direct payments, including the potential reference period for both eligible recipients and calculating the value. I think it was Strutton Parker who came out with a value of £750 a hectare in 2019, which is what people may be able to receive as a lump sum. And they're looking at the treatment of business structure changes since that reference period. However, the earliest that BPS payments can be delinked from land and entitlements is 2022, meaning BPS remains 2021, as we've said, albeit there is a reduction in the payment value and some simplifications to the rules looking at the greening. So ELMS, following the decision to leave the EU, the government has more than signalled its intention to replace BPS and countryside stewardship schemes with a new environmental land management scheme. Some of you may have been involved with the ELMS consultation that was due to be a really big tour across many village halls and smaller venues by DEFRA to liaise in person with farmers. That was due to be over this year. Obviously that hasn't happened. There was a lot of consultations online, like what we are doing now, and which people got involved in. So ELMS has been developed under the principle of paying farmers and land managers public money for public goods. Plenty of people have read about public money for public goods. So what is that? It's being defined at the moment as clean water and clean air, biodiversity and habitat management, beautiful landscapes, adaptation to climate change and flood mitigation, conservation of historic environment and cultural heritage, healthy soils and public engagement and access. It's not that focused at the moment, should we say. So there's few concrete details so far. We are told, according to George Eustace, who was on BBC Farming Today last week, that there's to be more detail launched in November. What we do know is that there's 3 tiers of support. It's looking more at collaborative working, and George Eustace mentioned that a farmer would work with a trusted advisor to devise a scheme and apply to get that support. So concerns or opportunities regarding this, I think there's personally, there's been realisation by DEFRA that some farmers will simply abandon the schemes if they're not worth it. What can they then use to enforce rules if cross-compliance or something similar is still to apply? It's obviously a lot easier to not give someone something you were going to give them, rather than to try to get it off them if they have fallen foul of the rules somewhere. As saying here, there's a hope that environmental work will be properly recognised and no longer based on an income foregone model of countryside stewardship, and it'll be a localised landscape-based approach. However, the concern is, will it be simpler, or is it just going to involve more paperwork and people? So Tier 1 and the sustainable farming incentive involve basic environmental measures in support of sustainable farming, such as nutrient management, reducing ammonia emissions, good soil husbandry. May also include basic land management, such as management of field margins and cover crops. Could it consist of a set standard that all farmers would have to meet, or a menu of options that farmers can choose from? The latest suggestion is that Tier 1 could be a simple annual contract rather than ongoing agreement, and DEFRA didn't recently announce the sustainable farming incentive. Many think they did. George Eustace actually talked about the sustainable farming incentive at the NFU conference in February this year, which is expected to be launched before ELMS, probably in 2022. And the expectation is it will then become Tier 1 of ELMS in due course. Their expectation is that most farmers will want to and be able to access the tier, and the government have realised that to deliver significant benefits there must be a high level of participation. Whether this can be achieved in practice will depend on whether there are enough suitable options for farmers to choose from and the payments are sufficiently attractive. ELMS Tier 2, that will involve land management options and capital funding designed to deliver a wide range of environmental benefits, which might include habitat management options, tree and hedge planting, options to mitigate flooding, restore and dry stone walls, permissive access and educational visits. We think agreements are likely to be offered over 3, 5 or 10 years, depending on the management options involved. This tier is more akin to the current countryside stewardship scheme, although hopefully with a wider range of options to reflect the different public goods ELMS is aiming to deliver. Tier 2 will need to offer significantly better payments than Tier 1 in order to encourage participation, and will certainly need to be more attractive than countryside stewardship if farmers are going to be able to make up the shortfall from the loss of BPS. The suggestion is that payments might comprise a basic amount for following the requirement management prescription, with a top-up for delivering exceptional results, an outcome-based approach known as payment by results. This is appealing as it enables farmers to be appropriately paid for the quality of the conservation work they do, rather than just following a set of rules. However, it needs to be balanced against factors outside of their control, such as the weather and unpredictability of plants and wildlife. ELMS Tier 3, that it is said it is reserved for projects that will deliver landscape scale environmental change, planting new woodlands, restoring areas of peatland and creating new areas of wetland, improved biodiversity and climate change mitigation on a grander scale. Is there a room here for a holistic approach, looking at whole farm plans, for instance? That is some of the conversations we've had with individuals and farmers as a collective, harking back to the Natural England Facilitation Funds, of which we've been involved in setting up a few. Now, it's likely to require a collaborative approach, again, between neighbouring landowners, and we see that payments are likely to be individually negotiated. And there's a suggestion that groups of land managers might bid for funding in a reverse auction, where there's one buyer, who's the government, but many potential sellers. The government is also looking into the possibility of supplementing funding for the scheme with private finance. So, summary of this is prepare for change. This is going to be decisions which is people and democracy led. So a number of people having their say in what rules and what farmers are due to follow. It may not always favour food production and landowners. There's going to be obviously a lack of spending power available to government due to COVID-19. And Parliament change will be likely, whereas the common agricultural policy structures were always longer than 5 years, and there's going to be pressure imposed by food imports and free trade, pressure also imposed by climate change and binding targets set by government for carbon neutral. BPS reductions are coming, we've touched on that. How will this affect farm incomes and rental values? Start planning now, I'd say, by taking up or certainly looking into countryside stewardship schemes, the productivity grants and the hedgerow and boundaries grants. Think holistically and be prepared to work with your neighbours. Think how much natural capital is on your farm and land. That's the amount of trees on there. That may be the amount of watercourses. Biodiversity offsetting, that's something we see becoming more of a thing as builders and utility companies seek to offset the biodiversity loss from where they're working on to working with farmers and landowners onto their farm. So can H&H Land Estates help you? Very, very quick plug. We're specialists in BPS countryside stewardship schemes. We've, in capital grants, secured one farm over 200,000 worth of concreting and new roofs over muck middens. We've got in-house and qualified experts and specialists, qualified with the Chartered Institute of Ecology and Environmental Management, the Institute of Chartered Foresters, and our BASIS members. Since 2005, we've helped over 900 farmers and landowners apply successfully for stewardship agreements. Thank you very much for listening. That's my talk. Next, we're moving on to Robert Fruin from the CLA.
Hi, everybody. And you've got me finally. I decided not to do death by PowerPoint. I'm just going to talk to you. It's going to be a hell of a fast gallop through. I've got a number of issues. Don't forget, if you're CLA members and you want more detail on anything I've talked about today, or any other help for that matter, it's all available for free, so just get in contact with me. First one up is septic tanks. Now, this legislation actually first came in 2015, but in January of this year, the last part of it came into force. And just it's a quick run through. It is quite important, but actually it's quite good news in many ways. So septic tanks now, this doesn't apply, obviously remains drainage. It also does not apply if you've got a cesspit, which is just a giant bottle which gets emptied before it's full. But any septic tank that discharges must now comply with the rules, and essentially your septic tank has to be in good condition, in repair. If there's a leak, if there's leaking or damaged, that is now an offence. And if it is an old two-chambered septic tank with a discharge and not a modern treatment unit, which has connected to mains electricity and has an agitator in it, they're fine, they're okay. But if it's an old-fashioned septic tank, and we've all got a lot of them around the countryside, I've got one here at home, if it discharges, you should check up on this. If it discharges to a watercourse in particular, you are in breach of the legislation. And there are two situations where you could be in serious trouble, or one of them's in serious trouble, one of them's just a problem. The first situation is if you are discharging to a watercourse and you actually cause a pollution incident. So fish end up floating in the river, the Environment Agency come out and they trace the problem back to your septic tank, then you are in deep doo-doo as much as the septic tank is full of it. The fines are absolutely massive. You're talking £20,000, and it's really not worth the risk. So if you've got a septic tank and it's discharging to running water to a running water course, and you think it might cause a pollution incident, or there's a risk that it will, please take action. The other situation in which it's a problem and it's solvable is where you're contemplating a sale, because I've given talks on septic tanks to rooms full of solicitors, all wanting to know what questions they need to put in inquiries before contract to check up on this legislation. And essentially, if you're selling a property, the buyer's solicitor is going to be asking very detailed questions about waste disposal. And if you have a non-compliant septic tank, you're going to have to disclose this to the buyer, and that's going to have a number of knock-on effects. First of all, it's likely to cause a delay to the sale. Secondly, there's every chance that the buyer will ask for a reduction in the price that he's originally offered, or the original price that's agreed, so that he can then make the system compliant. And knowing buyers, they're going to insure the amount, the cost thereof, and ask for more than the true cost of the works. So definitely the advice for contemplating a sale is to make sure your septic tank complies before you put the property on the market. How do you make it comply? The expensive way to do that is to put in a modern treatment unit. Take out the old septic tank, put in a modern treatment unit, which, as I say, is connected to the mains. It agitates the sewage, aerates the sewage, and what comes out the other end is deemed to be safe to discharge to a watercourse. But you're not going to get any change out of £10,000, and depending on the scale of it, it could be more than that. So it is an expensive option. The other option, generally much cheaper, is instead of having a soakaway or a discharge that runs to a watercourse, because even if it just goes into a ditch that doesn't run very much, in theory, you could be discharging to watercourse, and that's to put in a looped field drainage system. So this is basically a perforated pipe connected to your septic tank, and the discharge goes into that perforated pipe, and there is no end to the perforated pipe. It runs from your septic tank in a loop and back to septic tank again. So it doesn't discharge anywhere, and the amount of effluent that comes out of those very small holes in the perforated pipe in small enough quantities that soil microbial activity can deal with it perfectly well. That's probably the cheapest way to become compliant. But of course, quite a lot of people have septic tanks that discharge to a neighbour's field. They've got a right to do that. They almost certainly won't have a right to enlarge the system, so they're going to have to go cap in hand to the neighbour in order to comply. But the legislation is there. Now, we've spoken to the Environment Agency in some detail about it, and I actually had a meeting with a member up in Northumberland, and they came and inspected his system, and they have put in writing that as far as they're concerned, it's compliant. So that is one option, is to actually talk to your local Environment Agency guys. They've said to us that they do not propose to police this on any scale. They don't have the manpower to do it. So you are highly unlikely to get a knock on the door from the Environment Agency showing you proof of identity and wanting to inspect your septic tank. Even if that were to arise, unless you'd actually cause pollution, if they were there for something else and they noted that you had a non-compliant septic tank, I'm pretty sure, and that's the indication they've given to me, they would simply turn around to you and say, please, will you make your septic tank compliant? So I don't think this is an issue to panic about. If you've got a lot of septic tanks, because you're a larger landowner and you've got a number of cottages and so on, then what I would suggest you do is that you or your agents have a look at all of the septic tanks, make a schedule of them, put them in order of priority, so the worst ones first, and steadily work through making them compliant over a period of years. So I think that's all I'm going to say on septic tanks, because I'm conscious of time. I also know there's a question about septic tanks in the Q&A session. Now, very, very briefly on sewage sludge, this is climbing up the agenda. There are concerns about it, that there is stuff in sewage sludge that shouldn't be there. And we're talking things like hormones, recreational drugs apparently have been traced in sewage sludge, as have birth control chemicals as well. It is something we're looking at. I had a Zoom meeting with Lord Deepen about it last week. The worry is that if there is something in sewage sludge that we're not really now dealing with, or we're not really aware of, and it becomes an alarming issue, because of the Environmental Protection Act 1990, the Environment Agency at some stage in the future would be able to come along to you as a landowner and say, we know you've had sewage sludge spread in your land, and although it was done quite legally at the time, and we're not fining you or anything, so you didn't break any rules, unfortunately there was something horribly toxic in it, and we require you to remove it to a licensed site at your own expense. So just be aware of that one. There's going to be a consultation starting. We're trying to accelerate the process and have asked the minister to start the consultation quicker, because we don't want people left with a nasty shock in due course. So just be careful what you let people spread on your land, and that's a general rule anyway, I would say. Water. It's a huge issue, water, and we could hold a seminar on just on water. I think we're going to have a huge rethink as to how we deal with water in the future. If with climate change we're going to get wetter winters and drier summers, I think arable farmers, for instance, should start considering water storage on their land, so they can store it in the winter and use it in the summer. Or any farmer who's got a big need for high quantities of water. I think we're going to have a system of water management that from the top of the highest hill down to the sea. With any luck, we're going to see legislation that allows us to expand IDBs, which currently isn't possible. And I'm heavily involved in trying to recreate the IDBs in the Northwest. They were all abolished in the 1970s, and we have real problems over there. Half the Alt Crosslands, as I speak, is underwater right now, and that's a major salad and vegetable growing area. It's a real concern. So let me just see if I've got anything. Yeah, so that's really it on water. Again, I'm happy to take questions. Please do type them into the Q&A box, and I'm going very quickly, so we've got enough time to deal with those. Fly tipping, very, very brief touch on fly tipping. It's grossly unfair. That same act I mentioned, the Environmental Protection Act 1990, means that landowners have strict liability for anything on their land. So they wake up one morning and find an entire gateway has been full of a whole load of crap, courtesy of the local fly-by-night guys, and it's their responsibility. We'll go on raising it with the minister that this is unfair. We're battling for solutions. An obvious one is to reduce the cost of disposal so that it's simpler for people to take it to a proper site rather than dump it on our members' land. In the USA, some states charge $1,000 for littering. Should they be increasing the penalties for fly tipping and littering? Personally, I think probably they should. Very briefly, compulsory purchase orders. I do give a lot of advice on compulsory purchase problems. A wide variety of agencies have powers of compulsory purchase, whether it's the Highways Agency, the local authority, the local utility companies, Yorkshire Water or whoever. The moment you get wind of anything that you might get affected by a compulsory purchase order, first thing to do if you're a CLA member is ring me, because I can make sure that you get proper advice. Now, we can't act for our members, so I then would have to put you in contact with someone like Tim who would act for you. But do please instruct professionals. Tell them not to spend any money until you've actually been served with the official notice of entry, because from that receipt of that notice, the acquiring authority is legally liable for your costs, and that's your reasonable costs, both surveying and legal. So have your team ready, but don't spend a fortune until you've had that notice of entry. So ring me for the initial advice, and then get your team lined up to deal with it. Mobile mast sites is the last one I was briefly going to touch on. Is related to CPOs. The Digital Economy Act that came in at the end of 2017 drove a coach and horses through the way these are negotiated. We fought very hard against it, as did all sorts of people, including the government's own legal advisors saying, don't do it, you've been conned. But they were conned by the mast providers to include a clause in the Act which basically says, in calculating the rent, you have to ignore the fact that it's used as a mast site. So it's the existing use value. So Tim and Robert at H&H will have to be extremely imaginative on your behalf in demonstrating to the mast company going forward that there are lots of other useful uses for the mast site, and that could generate revenue, and therefore they have to pay an appropriate rent for it. But the government admits they got it wrong, but they're not going to find parliamentary time to do anything about it. So we've got to live with it. If you get approached now for a mast site, take advice, sharpish, give me a ring. In most cases, I'm probably going to say don't go there because the rents they're offering are derisory. And with any luck, if enough farmers and landowners say, look, we're not interested, it's not worth getting out of bed for, they'll have a rethink on the rents they're offering. I think I'm going to stop there because I'm trying to leave enough time for questions. So let me go to the Q&A box. Right, so I'm going to deal with the questions in order, and I'll ask one of the team to deal with it. And I think the first one is going straight to Sam. My farmhouse is free of any ties and is a substantial house. Is there any way I could transfer this house to my son now and not incur capital gains tax? Sam, are you happy to take that on?
Yeah, that's absolutely fine. So yes, you could transfer your farmhouse now to your son if that's your main residence, and it will qualify for principal private residence relief from capital gains tax. But if you continue to live in the farmhouse, then it won't be an effective gift for inheritance tax purposes, because you have to give up the benefit of living there for it to be an effective gift. and then after 7 years it would be out of your estate for inheritance tax. But if you continue to live in the property, even though you've gifted the title of the property to your son, you would have to pay your son a market rent to begin the 7-year clock for it to be outside of your estate. So really, I think if it's for inheritance tax, you either have to move out of the house and your son move in for it to work, or pay the market rent. But there shouldn't be capital gains tax if it is your principal private residence.
Thank you, Sam. Next one, again, I'm going to go through these quite quickly so to give you guys a chance to type in more questions as we go. I'm going to pick up this next one. Septic tank issue. I think I know who put this question in. I'll read out the question. This is a concern for me, particularly as my old house has both rain and dirty water going through the same drain, something that septic tanks don't like. You're quite right there. They don't like it. They don't work effectively. There must be many old houses facing the same problem. Interested if your speaker has any useful comments on the problem. I think in that particular case, if it's structurally too difficult and too expensive to separate out the rainwater and the proper waste that should be going to the system, one possible solution would be to consider installing a cesspit and simply emptying it 2 or 3 times a year. Simply get a local registered waste carrier to come and empty it, and you're not then discharging and into a watercourse. There's no risk of that, but nor is the rainwater interfering with the actual working of the septic tank. It's just all collecting in there, and you might have to empty it slightly more often than you would otherwise do, but it would solve the problem. Please give me a ring on that problem if you want to discuss it further. Next question. Sorry, my screen's jumped about. Would a bed and breakfast business operating in a farm location be eligible for agricultural property relief? The farm is small in this case and considered a small holding. If not, would BPR, business property relief, be available? Sam, again, I think this is over to you. Sam, you're still on mute.
I think it depends really. This is a wholly and mainly test perhaps to see whether business property relief would actually apply to the business itself. It won't be eligible for agricultural property relief, I don't think, but it would be looking for business property relief. And I think, Robert, you had some useful information about whether business rates apply in these circumstances.
Yeah, this is a really important one, please, for all of you. Time and again, I get calls from members who are farming members who've diversified to supplement their income, which they're thoroughly encouraged to do, and they have not taken account of business rates. All businesses are rateable and are liable for business rates. Farming currently has an exemption, although there are people, including a character called Dieter Helm, who are strongly arguing against that. But nonetheless, agriculture still has an exemption. Everything else is rateable. It's almost certain when you diversify, because everyone tends to start in a small way, that initially at any rate, you'll be eligible for 100% small business rates relief. The problem is that you can't claim it in arrears, whereas the local authority can go back to the previous valuation date to claim arrears of business rates. Now, that until very recently was 7 years ago, and I had a member almost in tears on the phone to me a couple of years ago because he'd suddenly got a bill for £80,000 of back rates and it was going to put him out of business. So please don't forget business rates. I'm going to go to the next question now, which I think I will talk about, and then Sam can jump in if she wants. This is on agricultural property relief. On a more general point, why does agricultural property owned freehold attract 100% relief and subject to protected AHA tenancies attract only 50% relief? This seems unfair. I agree with that it does seem unfair, but it is gettable around from a landlord's point of view. Modern farm business tenancies that came in September 1995 attract 100% relief, as does farmland farmed in hand. And whoever asked the question is quite right that AHA tenancies, the old style tenancies, only attract 50% relief. There's 2 ways around it. One is very simply to add land to an agricultural tenancy. If a farmer gives up land, it doesn't affect that. But if you add land to an AHA tenancy, the whole lot is then eligible for 100% relief. And the second way to do it is to do what is called a surrender and regrant. which simply, it has the effect of redating the tenancy post-September 1995. It doesn't affect the tenant's security of tenure, it doesn't affect anything else. It simply surrenders it and 10 seconds later is re-granted it by the landlord. If I was advising landlords, as I used to, we used to offer to pay any costs involved. I think we underwrote any risks of SDLT being payable. But those are the two ways of sorting that out. Sam, have you anything to add on that?
Just on the surrender and re-grant, just to check the tax implications, because there could be CGT, capital gains tax, but you've mentioned the SDLT already. But yeah, that's what I would have said.
Okay, question here from Philip Straker. What is the timescale for septic tank action legality? Well, the legality of it is that it became law last January, and so the action period in theory is now, but we have had formal notification from the Environment Agency that they won't be pressing on it. So I think all we can say then, they haven't given a time scale, all we can say is a reasonable period of time. And as I say, if you've got lots of them, then make a schedule of them and tackle any bad ones as soon as you sensibly can, and then just work your way through it. Rodney Swarbrick. Rodney, you've typed in Sam Edwards and nothing else on your question. Oh, they're underneath. Sorry. Yep, gotcha. One for you, Sam. APR and farmhouses. Rodney's question. It was typed in as two questions.
Right, yes, APR and farmhouses and farm profitability. Is it likely that adjustments will follow swiftly as profitability of farming falls? And I think this goes back to the 7 points of the character appropriate test, that it is taken into consideration. But in the Antrobus case, where it wasn't a very profitable farming business, it wasn't given much weight at all because all for profitability in the area had reduced. So I think it's something that probably won't be determinative as to whether your farmhouse is character appropriate or not.
And then Joe Payne has asked, I'm a partner in a farming business with a 50% split on the trading business of livestock and dead stock. Farm, land and business is held by my mother as a partnership business asset as per the partnership agreement. In the agreement, I'm the beneficiary of these assets on my mother's death. Would it be advisable to set up a trust to avoid future changes in legislation? Again, Sam, this is fair and square on you, I'm afraid.
That's fine, I'm just reading it. It was originally, sorry, the box has gone off my screen jointly
now. My parents, before my father's death in 2015, at that time, all assets went to my mother. I entered the partnership on the 1st of the 4th, 2019.
Okay, so I think that really here, the trust would only be useful of passing relievable assets from your mum's estate into your estate so that it isn't taxable on your death, or if you were to divorce, it's not part of your estate. So it could be useful, yes, and it would be better for your mum to put that trust in her will rather than for you to receive the assets and then do a deed of variation because a deed of variation is still a gift. So I think, sorry, I'll rephrase that. It's still a gift, but perhaps not for inheritance tax purposes if it's done within 2 years. But I do think that a discretionary trust may be useful. It just depends on your circumstances, and I'm happy to talk about them in more detail off screen. Is that the phrase?
We got one last question in from David Hutton Squire. I have contract farming agreement. My family's defence on my death would be I've always done the monthly accounts. I don't know if you want to say something briefly, or David, whether you want to give me a ring about that in due course, and we can. Oh, someone's typing one for Tim. I've got Anthony Roberts for Tim and then a blank screen. Anthony, you're going to type something because we are running out of time. Well, I'll start winding up. If something appears on the screen, we'll see what we can do. But thank you all very much for joining in this webinar. It's slightly weird as a speaker not being able to see who you're talking to and gauge reaction all of that, but we have to make things work in these very strange times that we have. If you want to contact any of the speakers privately, you know how to do that. If you're not a member of the CLA, please join the CLA, and then you get all my wise words for absolutely nothing. And hopefully I'll meet you when things get better and we can. Thank you to all of our panelists, all of our speakers. Thank you very much, particularly to EMG for hosting this event and getting the whole thing going, and everybody else who's been involved behind the scenes, including our wonderful Henk, who does all our PR, who put it all out on e-news, which so many of you reacted to properly. Don't think I've anything else to add. Very best wishes to all of you, and we'll close it there.
Thank you, Robert.
Thank you.